All right, good afternoon, friends. My name is Marie Pasiga, criminal defense lawyer here at ArrestedMinnesota.com. I wanted to talk a little bit about kind of a new case that came out from our Court of Appeals. And briefly, first, maybe I'll just explain so you can kind of understand the universe of what we're talking about. So we've got kind of three levels of courts in our state. There's the district court level, which is kind of think about the trial. When someone is charged, they go to criminal court. There's motions and pretrial proceedings and jury trials happening at the district court. And then if kind of either the state or the defense are unhappy with the decision, there's opportunities for appeal at the Court of Appeals. And then depending on what happens there may also be opportunities for appeal at the Supreme Court. The Supreme Court has the ability to make law and interpret the law. Basically, the Court of Appeals is an error correcting court, so they fix if there was any problems at the district court level. And then again, there's the trial court or the district court. Okay, so that's the three levels generally. So what happened in this case was that Mr. Nelson, he's the defendant in the case, he won his case at the district court level. So the parties were getting ready for trial, and his lawyers said, like, hey, prosecutor, you don't have enough probable cause to proceed in your case. And the facts that they relied on in a case were these. So Mr. Nelson was located in a Walmart parking lot. Law enforcement kind of found this vehicle where the driver, Mr. Nelson, was passed out behind the wheel. It sounds like one of the officers may have recognized him from an encounter earlier, but the guy was passed out. There was all of these kind of compressed air cans, which is basically like cleaning product, so dust off and things that you might use in an office setting. And law enforcement knows that those are intoxicating if inhaled, for example. But there was no keys in the car. The car was not running and the like. Okay, so these officers in that scenario are doing a welfare check to make sure he's okay. And I think they open the door, and the gentleman wakes up, and there's the car's not running, right? But one of the officers has an interesting question. It's pretty smart, actually. The officer just says, like, hey, well, how do we lock up the vehicle? Well, Mr. Nelson, it ends up finding the keys. He goes kind of and walks over and pulls the keys out of the well of one of the wheels of the car. And, the keys are present, obviously. So in that situation, he had priors, and the state charged Mr. Nelson with a felony, DWI, for being in physical control of this car while under the influence of the intoxicating substance. So the lawyers look through all the evidence. They make good arguments that this should be dismissed. There was no evidence that he was actually in physical control because the keys weren't in the car, not on his person, pockets, in the console, nothing. It's not running. It's in, outside the vehicle in a different space, in the well there, but they were successful. And so the district court, the trial judge said, no, you can't proceed, state, case dismissed. Well, the state wasn't happy about that, obviously, and said, this has a critical impact on our case, and we get to appeal that decision, Judge. Thank you very much. So they, file their briefs, go up to the appellate court, and the way that court works is that there's a panel. There's 3 judges that will sit on this panel, hear arguments, take written briefs, and then they've got their own law clerks that study the law, and then they issue a decision, okay? And what that decision basically said, and that's what we're looking at here, it's from August here of 2024, and it basically said, no, trial judge, you got it wrong. You should not have dismissed on that probable cause argument, because actually there was probable cause. In this situation where the defendant has knowledge and can articulate, where the keys are, that's enough where a jury sitting on, this kind of a trial could decide that that defendant was in physical control of the motor vehicle because he had the ability to operate the car at any moment, basically, is kind of the way the standard breaks down. So the judges said, no, you got it wrong, trial judge. We're going to undo your decision, and we're going to send it back to the district court for further proceedings. And what that means is there's a trial. So not all hope is lost. I mean, Mr. Nelson might very well have gone to trial. Maybe there was a plea negotiation. I don't know. I haven't checked to see the status of that case. But it's an interesting, I think, analysis here, and I guess kind of an interesting way that Mr. Nelson was trying to get around, being in physical control and trying to avoid criminal activity. But in fact, the judges decided that no, actually, if you've got your keys, even if they're outside the car and in kind of an unusual place like that, that can be enough for the state, number one, to charge that kind of a case and to get to a jury. We're not going to get you or let you off with a kind of a technical dismissal on a probable cause analysis. So that's the story on the case. If you have questions or concerns about your own case, give me a call, 612-339-5844. Thanks a bunch.